So we're going to be in worse shape trying to navigate the roads today. But
fully completely washed out. So
well, I'm sorry to hear that. Okay, so let me just give you an overview of kind of the way this works, because since you're representing yourself, let's just start with that question. Are you comfortable continuing to represent yourself or for purposes of this hearing as well?
yes.
I'm sorry, was that a yes?
Yes, sir.
All right, thank you, ma'am. All right, so the procedural history here is that on August 5th, 2025, when you appeared personally, you submitted to the court a lawful challenge to jurisdiction, standing, and authority, as well as an additional, that's a 2-page document, and then an additional 3-page document that was entitled Affidavit of Standing and Rebuttal of Jurisdiction. So generally speaking, the party who makes a motion goes first and argues his or her assertions. You don't have to, if you want to just stand on the pleading, that's what we call it. If you want to just say everything in writing is all I have to say, you can do that. But I want to give you the opportunity first to be able to run through the various points that you have. Then the people, and Mr. Bama is here on behalf of the people of the state of Colorado, the people will offer their position as to your arguments, and then ultimately I'll have to make findings and then also either grant or deny your motion. So with that said, did you want to go ahead and begin with anything you want to state?
Everything I have to say.
Before we jump into the courtroom, let me set the stage here, because this case is a perfect example of how confidence, bad legal theories, and real-world consequences collide. What you're about to see is a defendant representing herself, armed with paperwork, buzzwords, and absolute certainty, but very little understanding of how the law actually works. The judge knows it. The prosecutor knows it. And in just a few minutes, you'll see how quickly the illusion of control starts to fall apart. This case begins with a traffic stop that seems minor on the surface, but quickly escalates into something far more serious. A concerned citizen calls in erratic driving. A vehicle is failing to maintain its lane. And when law enforcement finally makes contact, the situation gets even worse.
Motion.
Yes, Your Honor, we have argument, and then we do have a witness. Caitlin Bills is on WebEx.
Okay. All right.
Intend to call her briefly.
All right. Very good. Do you want me to swear her in?
Yes,
now?
please.
Okay. Deputy Bills, ma'am, good afternoon. Are you able to unmute yourself and switch on your camera?
Yes, sir. Sorry, I'm trying to get my camera on.
No problem. I know it's a little cumbersome, so thank you very much for your appearance and your getting the WebEx machine thing to work.
Yeah.
Okay to myself.
Yeah, you can mute yourself. If you want to say something, just raise your hand and get my attention, and I'll and you'll have an opportunity, Ms. Raby, to cross-examine Deputy Bills. So what'll happen is I'm assuming Mr. Bama is going to walk through some direct testimony or solicit some of her direct testimony, and then you'll have a chance to cross-examine her. You can ask her questions about what she said during the course of her testimony. You don't have to, but that's your right. All right. Good afternoon, Deputy Bills. Nice to see you. Could you please swear or affirm under penalties of perjury that the information, that any testimony you're going to give today is the truth, the whole truth, and nothing but the truth?
I swear.
Okay, very good. Thank you, ma'am. All right, Mr. Bama, sir.
Thanks. Is it okay if I stay seated?
Yeah,
Okay.
stay seated. There's no
Okay.
formality required.
All right, state your name, please.
Caitlin Bills.
And were you employed as of 4/29/25?
Yes, as a corporal with the San Miguel Sheriff's Office.
And did you receive information about a traffic complaint when you were on shift?
Yes, sir.
And do you recall how you received that information?
Via San Miguel County Dispatch over
This right here is the first quiet red flag. Anytime a defendant chooses to represent themselves, the court immediately slows things down, not to help them win, but to protect the record. Judges don't want appeals later claiming confusion or unfairness. That's why you're hearing the judge carefully explain the process, the order of arguments, and the defendant's rights, but notice something important: the judge is being respectful, neutral, and methodical, not impressed. Self-representation doesn't give you special powers. It removes your safety net. There's no attorney to redirect bad arguments, no one to stop you from standing on legally meaningless filings. And when the defendant says she's comfortable continuing on her own, that locks her into everything that happens next. Here's the key thing to remember: courts don't operate on vibes, beliefs, or declarations. They operate on jurisdiction, statutes, and evidence.
The radio.
And what information did you receive?
Information about a black Jeep Wrangler or Rubicon Jeep that had a pink crown in the back window with temporary plates that was going a slow amount of speed on Highway 145, 1 mile marker 19, and that was failing to maintain a single lane as the vehicle was driving towards Norwood.
Mr. Adams was concerned, well, what was he concerned about when he made the call?
The driving behavior of the Jeep and the fact that it was going slow and failing to maintain lane. While also when he had passed that vehicle, he had smelled marijuana and seen the driver smoking what looked like a marijuana cigarette or something along those lines to him.
Mr. Adams had to actually pass this vehicle in San Miguel County to get around safely.
Yes, and he also had to hit his brakes because the vehicle was going so slow, so it impeded his traffic when he was trying to drive and his safety as well.
Okay. Eventually, did you come in contact with the Wrangler?
I did in the town of Norwood on Grand Avenue.
Why did you initiate a traffic stop?
I had seen the Jeep Wranglers stopped at a stop sign on Grand Avenue in North Pine, and it had sat there for an extended period of time. Then quickly turned into the marijuana shop, Alpine Wellness in Norwood. Within less than a minute, it had pulled in there. He had given good descriptors of exactly what he had seen and observed and smelled. I initiated the traffic stop and contacted the driver to see the radio.
And what was your tone when you first initiated the stop?
Conversational. Well, when I first started it,
That single sentence tells you almost everything you need to know about how this is going to go. When a defendant refuses to argue their own motion verbally, it usually means one of two things: either they don't fully understand what they filed, or they're relying on buzzwords they can't defend under questioning. Written filings don't magically argue themselves. Judges expect parties to explain their claims, cite authority, and respond to challenges. Standing on paperwork might feel powerful, but in reality, it hands control directly to the court and the prosecution. Because now the judge evaluates those documents in the cold light of law, without emotional performance or persuasion, and notice how the court responds: calmly, efficiently, and without drama. This isn't a showdown. It's a process. The judge isn't offended.
was the passenger, and then she had 3 young children in the back seat.
And eventually, you do have a conversation with the defendant, and I'll say that that's beyond the scope of what we're talking about today, but just to kind of paint the complete picture, you have a conversation with the defendant, and then is she ultimately charged with driving under the influence of drugs?
Yes, sir.
Okay. And did she consent to any tests?
Yes, she consented to voluntary roadside maneuvers.
And how about any chemical testing?
Yes, she consented to a chemical test of her blood, and when she consented, she said that there would be THC in her blood.
Okay. And what else did she tell you anything else when you were conducting your investigation?
She had told me that she had smoked marijuana It had been outside of her car. And this was after she initially had lied to me about that she hadn't smoked at all and she changed her story. But she had pulled over and she had smoked outside the car and it had only been one joint, even though the car smelled like burnt marijuana on the inside and there was burnt marijuana cigarettes that were visible in the ashtray.
Okay. For the purposes of this hearing, those are all the questions that I have.
So Ms. Raby, this is now your opportunity to cross-examine Deputy Bills about anything that she offered as testimony. If you'd like to do that, you're welcome to go ahead. You don't have to do it, but it's your right.
This is where the case quietly shifts from paperwork to reality. The prosecution doesn't argue theory, they call a witness. And that's a devastating move against jurisdictional challenges. Because testimony establishes facts, and facts create authority. The officer's role here isn't to debate law, it's to explain what happened, why action was taken, and whether it met legal standards. That's it. Courts don't need to prove abstract power when they have real-world conduct that triggers statutory authority. Pay attention to how routine this feels. The officer isn't emotional. She's not defensive. She's not improvising. She's recounting events as trained professionals do, chronologically and clearly. That calm delivery is exactly.
I don't know if I think just for protocol,
Ms.
I'm
Raby.
gonna open up to Miss Raby first.
Yeah. So did you want to, Ms. Raby, this is the time when you can make effectively what would be a closing argument, a summary of what your assertions are in support of your motion. Again, you don't have to say a word, but if you wanted to offer a global overview of what you're advancing in your motion, you're welcome to do that. Do you wish to do anything like that?
No, everything that I have to say is going to be written to you in certified mail.
Mr. Bamasur, do the people wish to make an
Yeah,
argument?
thanks. In order to make a traffic stop, the police must have reasonable suspicion that a person has committed a traffic violation or other offense. Suspicion is reasonable when there is an articulable and specific basis in fact to support it. And the police must have specific and articulable facts or rational inferences from those facts, would support a reasonable suspicion of criminal activity and thereby justify the intrusion into the defendant's personal activity. The reasonable suspicion here was articulated by Deputy Bills. And it started with a citizen informant, a ready report, if you will. And the ready report is something that has been dealt with in Colorado courts before, and they can serve to justify or create that reasonable suspicion. And I think in this specific case, that reliability is all the more established based on the fact that this was a trained law enforcement officer, albeit he was working for the jail at that time and not necessarily a patrol officer, but still law enforcement and still understands what's required when you're calling in a ready report. Also, peeling in front of the marijuana store and almost backing into Deputy Bills during the stop, again, that just leads to the reasonable suspicion for this stop and the site that I'll have.
This section is critical, and a lot of people miss why. The officer isn't just describing suspicious behavior, she's laying legal groundwork. Erratic driving. Speed issues. Lane violations. A citizen report. These are independent, articulable facts that justify a traffic stop, and notice how it's not just one issue. It's a pattern. Slow speed. Lane failure. Odor. Visual observation. The more layers that stack up, the harder it becomes to challenge the stop itself.